Early childhood services are obligated by law, service agreements, and licensing requirements to comply with the privacy and health records legislation when collecting personal health information about individuals. I am now going to demonstrate how I would explain privacy and confidentiality and its limits to a client. Privacy relates to an individual's ability to control the extent to which their personal information's enabling identification is available to others. And confidentiality is an obligation that restricts an agency from using or disclosing any information in a way that is contrary to interest of the person or organization that provides it. Confidentiality is of paramount importance in the center. This policy relates to the collection, storage, use, disclosure, and disposal of personal information such as photos, videos, and health information, and to ensure compliance with privacy legislation. Privacy and confidentiality are reinforced by legislation and underpinned by professional codes of conduct to protect mental health information from unauthorized disclosure. The information will be divulged in medical treatment or emergency, outside agency with parents' permission when required by national law, for example, the Department of Education in Early Childhood Development, with written consent from persons with lawful authority. All staff sign a confidentiality agreement upon beginning of their employment. The information can be accessed by the management, administration staff, relevant educators caring for your child, and there are some exemptions set out in the Information Privacy Act 2000 where access may be denied in the part or in total. For example, of the exemptions are the request is frivolous or vexatious. Providing access would have an unreasonable impact on the privacy of other individuals. Providing access would pose a serious threat to the life or health of any person, and the services involved in the detection, investigation, or remedying of serious improper conduct, and providing access would prejudice. Next one, I'm now going to demonstrate how I explain the duty of care to the client. Duty of care refers to the obligation to take responsible care to avoid injury to a person whom it can be reasonably foreseen might be injured by an act or omission. A duty of care exists when someone's action could reasonably be expected to affect other people. Education staff owe a duty to take a reasonable care to protect those children or young people in their care and control from the reasonably foreseeable risk of harm. If harm results from a failure to exercise the required standard of care, a negligence claim may result. Legal obligations to ensure the safety or well-being. Duty of care is also a legal obligation to ensure the safety or well-being of others. Duty of care includes maintaining knowledge and skills, complying with policies and procedures, responding when you identify children is at risk of harm, including making report of risk of significant harm, reporting all our allegations against employees in relation to child safety, working within your role of expertise, maintaining a safe work environment, recognizing and responding to the risks associated with transport activities out of the home, and situations where parents are not present to supervise a child or young person. And also recognizing the need for the teamwork within between agencies. Now I am now going to demonstrate how I would explain mandatory reporting to a client. Mandatory reporting laws aim to identify cases of child abuse and neglect and to assist individual children in these cases. It is mandatory to report suspicious of all 5 recognized abuse and neglect, for example, physical abuse, sexual abuse, emotional abuse, neglect, and exposure to family violence. Mandatory reporting laws define the type of situation that must be reported to statutory child protection services. Legislative grounds for government intervention define the circumstances and, importantly, the threshold at which the statutory child protection service is legally able to intervene to protect the child. It is mandatory to report if the child is 0 to 15 years old and they are at risk of significant harm. There are benefits of mandatory reporting requirements, which includes protecting the child from child abuse and neglect, increasing the awareness of child abuse and neglect in professionals who work with children, and overcome any reluctance to report this abuse. Who has to report? So mandatory reporting legislation generally contains list of particular occupations that are mandated to report cases of suspected child abuse and neglect. The occupation most commonly named as mandated reporters are those who deal frequently with children in the course of their work. For example, teachers, early childhood education and care practitioners, doctor, nurses, and police. In all jurisdictions, the legislation protects the mandatory reporter's identity from disclosure. In addition, the legislation provides that as long as the report is made in good faith, the reporter cannot be liable in any civil, criminal or administrative proceedings. I am now going to demonstrate how I would explain the professional boundaries to client. So professional boundaries are legal, ethical, and organizational frameworks that protect both clients and employees or workers from physical and emotional harm, and to help maintain a safe working environment. Professional boundaries are those rules and limits that prevents the line between carers and a client from becoming blurred. These are set by legal, ethical, and organizational frameworks to maintain a safe working environment for both client but also the caring staff too. Some examples of professional boundaries may include not discussing a client's private health information with others, keeping work contact numbers separate to your personal contact numbers, not performing additional favors for client outside of the scope of your role. Realistically, boundaries will occasionally be crossed or blurred at various points in care-client's relationship. This could be due to particular difficult situation like stress, bad lucks, or even manipulation by the client. For example of boundary crossing includes receiving gifts, inappropriately disclosing personal information such as phone numbers, address, also agreeing to socialize outside of the clinical setting, breaching confidentiality, inappropriate verbal or physical aggression, inappropriate touching or sexual contact, keeping information to yourself, just for example you're not documenting it, shopping for the person on your own time or with your own money. So those are examples of crossed boundary. In this situation, such as this requires us workers to have a clear understanding of our role in ethical principles and the organization's policy and code of conduct. That's the end. Thank you.